I just want to thank the three of you for putting this on, and I want to welcome all the state association partners and our NACM partners to this leadership seminar. It's going to be a great session. I'm looking forward to it. Some on the call have participated in the leadership seminar the last few years as they're in their consecutive term as president or vice president of their state. But for those that are in their first term, I'm glad you were able to join. Sorry it's virtual, but the presenters are going to do a great job for making up for it being virtual. But just wanted to point out that all of you know, and we talked about it all year long on the state association call, that we typically do this to kick off the conference, and it is a invitation only for the state association leaders and our various NACM partners. So we still wanted to keep this by invitation only. So hopefully you're enjoying the virtual education conference as part of our ongoing weekly series. But this is in addition to it. So I just want to thank the three of you for putting this on and looking forward to it. Thank you.
Thanks,
My
Kathy.
pleasure.
Really appreciate that. And I see that TJ Bement has joined us, the current president of NACM.
Hey, Jeff, can you hear me okay?
We can hear you loud and clear, TJ.
Great. Well, welcome everybody. My name's TJ Bement. I'm the current NACM president and a court administrator down here in Georgia. I wanted to welcome all of our fellow state association and partner leadership to this joint presentation between NACM and NASJE. Kathy, who you just heard from a moment ago, did a great job working with Jeff and her NASJE colleagues to put this together. So we hope that you all have an opportunity to learn a little bit from one another here today. And we'll be on to jump on at the end and say a few things and join in the conversation from time to time. But y'all are in good hands, and we appreciate you all joining us today and working with Jeff and his colleagues. So Jeff, back to you.
I wanted to spend a couple seconds introducing you to our panelists, or at least allowing the panelists to introduce themselves. I'm Jeff Schrade. I'm the Director of Education Services here at the Arizona Supreme Court AOC. I'm a colleague of Gabe's. We work in Phoenix, Arizona, and are involved in the National Association of State Judicial Educators. I see some familiar names on the list. Some of you I've had the opportunity to meet in person from our previous iterations of this leadership program that we've done. Let me see, where did we hold those? In Las Vegas, and I'm forgetting the previous one, but this is our third year that we've had this joint program between NASJE and NACM, and we're really excited about delivering it remotely this year under the circumstances. So it's great to be with you, and I'd like to give an opportunity for Todd Brower to introduce himself to you as well.
So hi, I'm Todd Brower, and I'm the Judicial Education Director for the Williams Institute at UCLA. I'm also a law professor, unfortunately not at UCLA, but in Orange County, California. And I'm actually the president-elect for NASJE. So you have three NASJE people here, and I'm really very pleased to be invited by NACM to participate. And I guess I'll turn it over to Gabe.
Thank you, Todd. Thank you, Jeff. And then thank you to our friends at NACM for hosting this. As Jeff said, my name is Gabe Goltz. I work with him in the Education Services Division of the Arizona AOC. And just a little bit more background. I am not a court person. I'm not an attorney. I am a political science and government nerd. Those are the things that I study and I'm into. I teach the Purposes and Responsibilities of Courts class for the ICM, which is why I'll be talking about what I'll be talking about in just a moment when we get going. But that's my background, is sort of the more civic principles that go along the judicial branch. So it's a little bit about me. So our program today is going to be focusing on both the purposes of courts, which some of you may be familiar with, maybe many of you are familiar with, but then extending it into the issues of public trust and confidence, and specifically what we're going through now. I'm going to take the first segment of our program today, which will be focusing on the purposes of courts. So Jeff, if you could move on to the next slide, please. So the purposes of courts. We all know courts must have purposes. Everything has a purpose. And so do courts. And The purposes we're going to be talking about today, the 8 purposes of courts, were developed by a gentleman named Ernie Friesen. I hope all of you are familiar with Professor Friesen, and better still, hopefully maybe you've even met Professor Friesen. Just on a personal note, I was really lucky. If you've ever taken the purposes and responsibilities of courts class that I mentioned earlier through the Institute for Court Management, I was actually privy to taking the very first iteration of that program that was ever offered nationally when it was developed. And one of the co-faculty was Ernie Friesen. So I was really fortunate to be able to meet and learn from Ernie Friesen. But then the question some of you might have is, who is Ernie Friesen? Professor Friesen, maybe one way to put it, is the godfather of court administration. He came of age in his court professional career at a time in the 50s and 60s where court administration was just starting to come into its own. And if we think back to a time, there was no profession of court administration. It was the judge, presiding judge, if it was multiple judges, and then staff. And that's how courts were run. And then over time, as management science generally sort of came of age in our country, court administration itself, and Professor Friesen was one of those first people that really carved out that niche. Among other amazing accomplishments, he was the administrative director for the US AOC. He was also the founding executive director of the National Center for, the Institute for Court Management, not the National Center, and then also the founding dean of the National Judicial College. So he has an extensive background in running courts and court administration. And at one point, and forgive me that I don't know the exact year, it was the late 60s or early 70s, I believe, he happened to be working with a group of court administrators. And he said, you know what, why don't we talk about the purposes of courts? Why do courts exist? Now we ask ourselves, why does that even matter? And for those of us in leadership positions, we know that mission statement, vision, values, or purposes, another way of approaching that, are vitally important for us to know what we should be doing and also what we shouldn't be doing. So in working with this group of court administrators, they developed 8 purposes of courts. And so we're going to be going through those shortly. But I wanted to make sure you all obviously are familiar with Professor Friesen, but also understand that these are his 8 purposes. Now, they've been taught and debated ever since, whether or not there should be more, whether or not they should be less. And the judicial branch really has coalesced around these 8. Now, I'll talk at the end a little bit about potentially some additional purposes. But to move on into these 8 purposes, the first purpose is to do individual justice in individual cases. Now, we think of this as essentially the core purpose of courts. Why do we have courts? To do justice. But if I took a poll, and maybe just even in this class with our 25 participants, and asked, well, what is justice? I would get 25 separate answers. It's much harder to define justice than it is to focus on this concept of the individual. Professor Friesen and his colleagues wanted to stress that it isn't just doing justice, because that alone is a nebulous and tough to define concept, but to really focus on every individual, dealing with individuals and their cases, their issues. Now, some of you probably supervise frontline counter staff who may, hopefully behind the scenes, make comments about frequent flyers that they see who come into court a lot. And it's easy for all of us in our job to say, oh, well, I've seen this before, I've done this before. But when we think about the importance in courts of individual justice, that individual, their case is unique, their needs are unique, the facts, everything involved is unique, and individuals need to be felt like they are treated in that unique way. So to do individual justice in individual cases. Now this feeds into our second purpose of courts. And if we can move on to that, please, Jeff. To appear to do individual justice in individual cases. I promise you, the 8 purposes are not just a series of restatements of the previous purpose, but this is an important one we really want to focus in on, and it's a nice segue from that discussion of the individual. Now, in the judicial branch, we talk a lot about appearances. A lot of your codes of conduct, Arizona's included, include the notion of appearance, the importance of appearing to do ethical behavior. What is so important about this notion of appearances and being distinct from that notion of, actual justice, as it were? Why do we care about the appearances? If you could raise your hand and we'll unmute your mic. Anybody have any thoughts on that? What's so important about that notion of appearances? Sean O'Sullivan. Let's see if I can unmute your mic.
Yeah.
Oh, there you go, please.
Yeah. The appearance is important because justice must be seen to be done. A justice, even if a result is just and it's done behind closed doors, that doesn't help the system where when it's seen, the appearance of justice is out there, that helps build confidence in the system and confidence from people that when they come to the system, that they will get a just result.
Hey, that's a wonderful answer. Thank you so much, John. I appreciate that. That notion of it being seen. We in Arizona have a relationship with the Japanese Supreme Court where every about 9 or 10 months they send over a judge from their judicial branch. It's a unified system. So they send over one of their judges throughout Japan to spend about a 10-month sabbatical in Arizona. And they go to law school classes. They come to our judicial training programs. It's a really neat program. But one year, one of the judges gave me a beautiful coffee table book that talks about the Japanese Supreme Court. And if you've never seen the chamber where they do their hearings, I would encourage you to track it down online. It's a beautiful room. But one important thing is it has a gigantic skylight above the justices. And it's their way of communicating that justice will be done out in the open, in the daylight, where it can be seen, which is, we think of a hallmark of democracy generally. But then Sean touched on that notion of public trust and confidence. Now, I'm not going to get too far into that. My colleagues later in this program are going to be focusing in on that. But that notion of it has to be seen for people to know that it's being done. It's a form of accountability. Does anybody else have any thoughts they want to add about appearing to do justice or appearances? What's the importance of the appearances of it? There's one more concept I'm going to key in on, and again, I'm going to talk about just ever so briefly because Todd's going to be talking about it later, but it's important to note here because it's connected both with this purpose and the previous. Any other thoughts on appearances, the importance of appearances? Well, some of you may be familiar with the concept of procedural justice, and that's the idea that an individual feels like they've received justice. Now we think about, well, how can someone feel like they've received justice? Well, all the things that go into procedural justice, which again, Todd's going to talk a little bit more about later, but that notion of somebody feeling like they've gotten justice. Justice looks a certain way. Now, on a surface level, we can think about things like a nice courthouse, a judge in a robe, or other aspects that we might kind of consider traditional ways that justice looks, but also how an individual is treated. Are they listened to? Things like that. It's so key that not just doing justice, but that it looks like justice for exactly the reasons we're talking about in terms of both the litigants, the parties feeling like they've received justice, but then also for the public to feel like they're receiving essentially their money's worth. Number 3, please. To provide a forum for the resolution of legal disputes. This is the ancient purpose, right? We can think back to a time in our world where perhaps individuals in a clan, a family, a community might gather around a meeting point, a fire or something like that, the elders of a tribe, and decide how to resolve a particular dispute. This is an ancient form of courts. This is what courts provide, a degree of civility in terms of arriving at difficulties. We all know life is messy. Now, when I talk about the alternatives, if any of you are English philosophy fans out there like I am, you'll know that a philosopher named Thomas Hobbes once described what the world was like before government. I will mail a prize to anybody who can raise their hand and tell me how he described the world before government. Does anybody happen to know that famous 3-word quote? I guess it's technically 4 words. All right, none of you are quite as nerdy about English philosophy as me. Thomas Hobbes described world before government as nasty, brutish, and short. Oh, thank you, Jeff. Good job. Nasty, brutish, and short. Jeff, I'll send you a prize. He's down the hall for me, so it won't cost much in postage. No, nasty, brutish, and short. So when you think about ways that we can solve disputes, in Arizona, we obviously think a lot about the Old West. They had ways to solve those disputes. They went outside and stood in the street 10 paces apart and fired their guns at each other. That's one way to settle a dispute, all right. We can do it by force, persuasion, conning someone. There are all kinds of ways to do it. But we think about the importance of courts as providing that location that is civil, that has rules, that is supposed to be dignified. So I often will remind new judicial branch employees when we think about all of these things that are easy to take for granted, like wearing a robe or courtrooms looking a certain way or judicial branch employees acting a certain way. It feeds into this notion of having a dignified forum for the resolution of those disputes. Now, civil cases are normally where we think about that, right? Where two private individuals have some dispute. Maybe someone feels that their property was taken or their land was taken or they were in some way wronged. Obviously, criminal court is also a dispute between legal parties, but it's in a much different way. We might think of that as an individual's dispute with society or society broadly, their dispute with an individual who's broken laws. But really, we think about number 3 as being much more situated within that civil realm. Number 4, please. This happens to be my favorite one, and for those of you that might be con law junkies and know the history of some Supreme Court decisions, this might be yours too. To protect individuals against the arbitrary use of government power. Now, does anybody happen to know who that individual pictured on that slide is? You can either raise your hand or fire it off in the chat. Does anybody know who that individual is? Hey, Greg Lombard, Gideon, absolutely. Clarence Earl Gideon. Clarence Earl Gideon was involved in the famous Supreme Court case, and I believe it was 1964, that essentially established the right to counsel. The right to counsel existed, of course it exists in the Constitution, it had existed for a long time, but in a very limited set of circumstances. And his case essentially broadened that to include all cases where someone might go to jail as a result. The case is more complex than that. I'm not intending to provide a discourse on Gideon versus Wainwright, but this idea that courts exist in part to help protect private citizens against other forms of government. Now, this is a bit of a conundrum when we think about it. Courts, of course, are a part of government. So yet, courts exist within government and as a remedy to government. Now, if you know your checks and balances and Civics 101 type concepts, of course, each branch can check the other in unique ways and serve as a protection against one branch becoming too strong. But this has traditionally been a special purpose or a special realm that courts uniquely exist in, to provide individuals the opportunity to contest what government might be doing against them. Of course, we have rights that are independent of government, and we form governments to protect our rights. Well, occasionally individuals feel that government is not protecting their rights and in fact is violating. So courts are that venue that individuals can go to as sometimes a first resort or last resort to help protect their rights. Number 5, please. Whoops, there we go. To provide a formal record of legal status. Now, this is something that involves probably a bulk of the work that courts do, or the personnel in courts. When we think of clerks of court, whether that's a formal elected office like it is in Arizona, or individuals that we think of as being court clerks, whether they work in a courtroom or at a front counter, for example. A formal record of legal status. Now, I want you to take a moment and think about some of the meetings that you've been to throughout your professional career. I'm sure we've all been to those meetings where you sit down and discussions begin and you think to yourself, gosh, didn't we already decide that? Didn't we already discuss that issue? Well, of course, that happens. And when there isn't a good record of what occurred at the previous meeting, what we would normally think of as being meeting minutes or some record of the meeting, it causes inefficiency, delay, frustration. Well, in the same way, but in a much more powerful way, courts provide that formal record of legal status to individuals, or what we might consider as finality. Think about all the things that courts do that are important finalities for individuals. Perhaps a marriage license, or adoption, name change, the set aside of a conviction. In Arizona, we have a proposition on the ballot coming up in November that relates to recreational marijuana. And part of that proposition is discussions of setting aside previous convictions for certain specified offenses so that individuals no longer have those convictions on their record. Think about how important that would be to someone to have a sense that their record is clean or their rights have been restored. Finality, it's such a critical thing just for our everyday life. Think about how life would be if you perpetually had a case hanging above your head. A colleague of mine and I, we teach a class on Franz Kafka's short story, The Trial, and for those of you that are familiar with that, it's a story about an individual for whom there really is no end to his case. He doesn't even know what the case is, but beyond that, it's made clear to him by his attorney that there never really will be an end to that. And it's meant to convey a perpetual anxiety. Well, courts are intended to combat that, to be able to say, look, this situation is done, whether it's a case or any of those other things I named. So it's critically important that courts provide that formal record of legal status. Number 6, please. Whoop. There we go. To deter criminal behavior. Now, this is one of those purposes, and these last a few that we're going to get into, these last three, all involve working with other parts of the government system. We have other stakeholders here, but to deter criminal behavior. Now, a lot of times when you teach these purposes to individuals, especially new individuals in the judicial branch, you'll see a lot of eyebrows raised because individuals think, well, no, gosh, isn't that what law enforcement does? Police, sheriffs, whatever your local law enforcement is. Well, sure, that's part of their job, is to deter criminal behavior. Their presence will often keep criminals from potentially engaging in their criminal conduct. You think about police officers having parked their cars onto the side of the road. I'm sure all of you do what I do, which is you immediately slow down, even if you're already going the speed limit or below the speed limit. You immediately slow down and check to make sure you are, and you drive very cautiously and slowly by that police car. Well, in the same way, the mere fact that courts exist helps deter criminal behavior, and the way that that's done is through speedy trials. Individuals in society have to know that should they choose to break the law, there will be consequences. If someone is not going to be punished for years and years and years for whatever crime they happen to commit, well, they might think it's worth it. Knowing that there is immediate punishment is a deterrence. Now, for those of you that may have probation in your system, and I'll talk about this in a moment, this is something that probation is starting to learn nationwide, that the idea of swift consequences to a violation of probation yields much more compliance by probationers, knowing that they'll be dealt with immediately. So this is an important thing. Now, we have a clip here from Professor Friesen, so you'll get to see Professor Friesen in action, talking about why speed is itself so important to the judicial branch. Jeff, if you could play that clip.
Time is a justice measure. So when you're keeping track of when something happened and the next event and the next event, and you see things put off over and over again in a court, you're really looking at the loss of justice in the system.
What a great quote by Professor Friesen, and it really hits home going back to purpose number 2 about appearing to do justice. If justice drags on, and Jeff is going to talk a bit more about this in a moment, it doesn't look like justice. So it's important for us to help deter criminal behavior and appear to do justice by moving cases towards finality. Number 7 is rehabilitating persons convicted of crimes. Now, it's surprising to me, at least, being a newbie, somewhat newbie, to the judicial branch, to think about this having been something that was formulated way back in, like I said, let's say about 1970 or so. Because I still think of this as a somewhat new purpose of courts, and I'm sure you've seen this similarly in yours. I'm sure many of you have heard over time a judicial officer say something like, "I'm not a social worker." And we associate this with specialty courts oftentimes. Courts that are focused on meeting usually a criminal defendant's needs, a convicted criminal, their needs in a different way, or a diversionary type program. It's a complex role, and courts don't think of this as traditionally being our role, but of course it is. Now, sentencing is the traditional way that we might do that. Judges can do great things at sentencing. Now, of course, sometimes sentences are spelled out in law very specifically, and judges have little discretion. But when judges do, they can use those to help change someone's life, whether it's words they speak or the type of punishment that they implement. And I mentioned earlier about probation officers. I know not all of you have probation officers within the judicial branch. Arizona does. But their role is very much also to help rehabilitate persons convicted of crime. So in Arizona, this number 7 takes more than just the judicial officer, but those probation officers. So it's an important thing that courts do to not just convict individuals, but to help change them and rehabilitate them and reduce recidivism. It's a role that courts increasingly are playing an active role in nationwide with innovation and innovative programs. And number 8, please. When all else fails, separate those convicted of crimes from society. Now, again, this is sort of an all else fails type role, but it is still something that we do. And oftentimes judges will have discretion to determine whether or not incarceration is the appropriate outcome to a criminal case or not. And although this purpose does specifically say convicted of crimes from society, I also want to focus on the role that courts play with individuals who are seriously mentally ill and may pose a threat to themselves or to others. They may not be convicted of a crime, but we as a society have regarded them as being a particular kind of threat. And it's the judicial branch who has stepped in to fill the void to help determine that an individual does in fact need some form of a forcible, not incarceration, but placement within a mental health facility, and whether or not they should stay there. Arizona, again, the system that I'm most familiar with, has a very robust system of continual hearings every certain number of days to make sure that an individual should still be within a mental health facility. So that role of, again, helping protect society from individuals who may be dangerous and for whom have earned a particular punishment. So finally, if we could move to the next slide, just to think about it here. So those 8 purposes have stood the test of time, and I'm not going to ask you to come up with other purposes. Know that this is still being debated within the court administration community to actually know what is the role of courts and the judicial branch. There's an article by a good friend and colleague of mine named Kent Batty. It appeared in NACM's magazine where he actually proposed 3 additional purposes. He is a protege of Ernie Friesen, has spent his career thinking about those 8 purposes and additional purposes. Again, we're not going to get in that here, but know that there may be additional purposes and that may change over time. But we think about these 8 purposes as really being the core of what we do as a judicial branch. They're a measure of what we should be doing and what we should be doing, and if we're doing it well. So I always encourage individuals with these 8 purposes is to copy them, put them up in your office or your cube, hand them out to new employees. I think it's a great way of teaching what it is that the judicial branch is all about. So now that I've set the stage for these sort of fundamental 8 purposes, we're going to transition now to my colleague, Jeff Schrade, who's going to be talking a little bit about some of these concepts like public trust and confidence. So, Jeff, please take it away.
Thanks, Gabe. Well, you know, I was frankly getting pretty excited about spending some time in July in the Big Easy with you all, sharing some great jazz and some beignets and maybe a couple of hurricanes along the way on Bourbon Street, but that didn't happen. And what has happened instead is the pandemic. We might look back at this and see the last 6 to 9 months months into the future now as well, as one of the, if not the biggest challenge in our professional careers. We've all been, had this thrust upon us kind of out of the blue without much preparation at all. Some courts are more prepared than others, but it's forced us, and as it's forced the rest of our community, our worldwide society, to adapt and to change business processes and practices to conduct business under the pandemic. And this has been especially important for courts because the work of the court must go on as an institution, an important and crucial institution in our society. And so we're going to spend this part of the program looking at, in the framework of the purposes and responsibilities of court, just what facets and how those facets of the pandemic have interrupted or created challenges for us to operate within those purposes and responsibilities of courts. Now, I'm going to raise many questions and examine those challenges. When Todd speaks, he will give us all the answers to those challenges. I'm just kidding. He will give us a toolbox and some ways to kind of address and think about approaching those challenges as a court. But for this section of the program, we're going to really examine some of those challenges. Again, I encourage participation using the chat function, or if you'd like to make a verbal comment, go ahead and raise your hand and I'll turn your mic on. So, you know, this concept that Gabe mentioned as part of purpose and responsibility number 6, the clip we saw with Ernie Friesen that was shot sometime in the early 2000s. This concept of justice being time sensitive goes all the way back to 1215 and the Magna Carta. The Magna Carta actually said, to no one we will refuse or delay right or justice. So this idea that justice must happen in a timely manner is very important. We also saw this kind of very famously in Martin Luther King's letter from Birmingham jail in 1963. And so this idea is not a new idea. It's a vastly important idea. And I think this is where the challenges from the pandemic kind of start. I remember traveling to visit my brother in Denver, Colorado, on his birthday, January 24th. I flew with my son over the weekend. Between the time that we arrived in Denver and flew back, we started to see the first U.S. cases. And as we flew back, we saw maybe about 10 or 15 people in the Denver International Airport wearing masks. And again, that was the last week in January. It developed very rapidly. So by the time we entered March, we saw cancellation of educational programs, some court processes being changed. And then in Arizona, in April, we went into a statewide lockdown where everyone was home and everything came to a screeching halt. And so we're about 6 months into those effects starting in March, and now is September. And it slowed things down considerably. Not only did we come to a screeching halt with the shutdown, but the justice system is largely built upon people appearing in person in court. Justice is it's one of the most human things that we conduct in our society, and so it takes advantage of being in the same location face to face. And so we've had to adapt a lot of those processes too, and it's taken some time. We've done it extremely rapidly, and the entire United States court system is really adjusted quite rapidly. But time is our biggest enemy. Time erodes justice, and a lot of the challenges that we've faced from the outset have led to delay. And so let's think a little bit deeper. Not only has this led to delay in our court processes, but this has caused effects within our communities as well. We talk about access to justice. What are some of those things that have been impaired as far as the public's access to justice? What are some of those things that have been inhibited as far as the public coming to the courthouse? Here's a picture of a common sight in court entry. Here we have someone who's wearing a mask, passing a temperature check before they're allowed into the courthouse. But this isn't the only thing. This is kind of one of the things that's very visible. The things that are not quite visible: public transportation. A lot of the folks coming into court rely on public transportation, which has been a lot more difficult to ride safely and a lot less available under the pandemic. A lack of access to technology. We'll talk a little bit more in depth about some of the remote hearings that are taking place, but we know in our community there's vast differences in that access to technology. Some people access technology through the public libraries, and in many cases those public libraries have been closed and are still closed today. So these normal issues that are always there as challenges to access to justice are amplified during the pandemic. So before kind of court business users, folks involved in litigation can even get to the court, there's all these challenges that they face. And then of course there's the challenges at the doorstep that they face. And there are challenges to our court operations. I really hope that not many folks who are involved have experienced, someone on their team having COVID and being out. But we know that, in Arizona, we've actually started working in teams so that we don't have the entire group of personnel, the entire division in the office at the same time. So if there is exposure and we have to go into quarantine, it doesn't take out the entire office. But nevertheless, we're seeing some absenteeism caused by sickness, caused by illness. We're counseling employees to err on the side of caution and not come into the office if they have any symptoms at all. And this is leading to courthouses being closed. This is leading to matters being rescheduled. And anyone that's involved with case flow and calendaring and scheduling knows that this is kind of a domino effect, and gets amplified the more that it happens. That backlog increases as time marches on and there are more delays. And so again, this time is our enemy, and the pandemic at the most basic level has exacerbated a lot of the challenges associated with timely justice. Let's here we have two judges promoting masks and wearing masks, and if you can see by their little signs, they've got a I wear a mask for healthcare workers and so on. So, let's frame this as the arbitrary use of government power. I remember on February 28th, we did a webinar here in Arizona for judges who had been designated in our superior courts as public health emergency judges, as hearing public health matters. And it was an interesting area of law where the government, under the authority and the powers vested in them, mainly in the executive branch, could take extraordinary measures to protect the public against a public health crisis. The masks are just one kind of visible part of this, but usually public health authorities have the authority during a public health crisis to compel quarantining and restricting rights to travel and so on. And so it's kind of not an awkward position, but a challenging position for the courts to be the check on the arbitrary use of government power, but to have these extraordinary circumstances where the law and the circumstances themselves call for extraordinary government action. But again, that due process, that check on arbitrary use of government action is just so important. And again, it kind of amplified during the public health crisis and the pandemic that we're dealing with. Let's talk about this other facet, and this is separating those convicted of a crime from society. Gabe mentioned that probation is, in the judicial branch here in Arizona. But one thing that we've seen in jails and prisons throughout Arizona, and I think throughout the rest of the state, here's a clip from Texas where jails faced with overcrowding have let folks out early. And so we've got more people who have been convicted of a crime returning to society because of those challenges with incarceration and the close quarters and the spread of COVID within correctional and jail facilities. And so this is a real hot button issue that I think we should be aware of as well, that the public that resonates with the public and has some influence on the public trust and confidence in the court system. And so we might see more coming of this trend here, with folks being released from jail and prison early. I mentioned probation. One of the key ways for rehabilitating persons who have been convicted of a crime so that they can rejoin society is through the practice of probation. And probation officers usually rely on kind of face-to-face and in-person contacts and regular contacts to ensure that the folks that they're monitoring are in compliance with those conditions of probation. That's changed during the pandemic. There's been the allowance for a lot more remote interaction, and there's been the relaxing of those conditions of probation. And so here's an article that I clipped from that covers this practice in Los Angeles, California. But across the nation, the same thing is going on. And there's some folks who say, well, this might not be a bad practice to continue beyond the pandemic. So we'll, keep looking at this trend as well. One of those things that has not quite hit in the tsunami that we anticipated is evictions. I know in Arizona, we've had some executive branch action in stemming evictions during the public health crisis. And by now, you're probably all aware of the Centers for Disease Control having a blanket order preventing evictions through the end of the year. And so this is a very tricky situation for the courts as well. We exist, again, that ancient reason to provide a way to resolve legal disputes. And a landlord and tenant, that relationship is defined by a legal document, a lease document. It is the pure responsibility of the court to be the place where issues arising out of that legal agreement can be resolved. And so we know in a lot of cases, the way the law is, when folks can't or don't pay rent, there's a remedy for the landlords, and that remedy is eviction. Does that make sense during the public health crisis to put people out on the street? The answer for now is no, by the Centers for Disease Control and the executive branch action that's taken place in a lot of other states. But these cases will nevertheless come before the court at some point, and the court will have to make decisions based on law. And those decisions might not be popular and might really impair and impact the public's perception of the court system. In fact, this was mentioned the other night on John Oliver's show. And so I've got a little clip I want to share, just kind of looking at his analysis. It's kind of comical, but at the same time, it's very serious and biting as well, that might kind of help to define the public's perception of the courts as it relates to evictions.
Moving on, our main story tonight concerns the coronavirus. Among other things, the worst thing to happen to weddings since flash mobs. And the reason we're talking about it is that we have a huge COVID-related catastrophe that's actually just around the corner. It's true. The coronavirus crisis could also soon turn into a full-blown homelessness crisis. And it's hard to even fathom something already so bad transforming into something else so appalling. And it says something about the utter absurdity of what's about to happen, that this is how some eviction hearings will be taking place.
Starting with tomorrow's docket, Judge Lopez will start hearing eviction cases, either in the court, using webcams with the defendant and the plaintiff in separate rooms, over Zoom, or even on the phone.
What are you doing? You know, it might be worth thinking twice about what you're taking part in if you're throwing people out of their homes via Zoom, a platform you're only using because it's not safe for people to leave their homes.
Boy, like I said, very challenging, and it puts the court in a very difficult position, because it's our obligation to continue to administer justice and to do it in a timely fashion. And so we've moved a lot of hearings, including eviction hearings in some cases, into the remote platform of Zoom. So let's talk about Zoom. We're on Zoom right now. America has existed on Zoom, I think, for the last 6 to 9 months. And like I said at the beginning of our program, we've all become kind of Zoom experts at this point. But does that method of administering justice and conducting remote hearings over Zoom bring with it any challenges to the purposes and responsibilities of courts? Let's ask that as a question to the entire group. What challenges do you see to the purposes and responsibilities raised by holding and conducting remote hearings on Zoom? You can either put your comment in the chat box or raise your hand and I'll open up your mic. Well, as you're thinking about that, let me throw a couple out there. You know, what do you see in this picture? This is just a kind of a random screen grab of a Zoom that was taking place. You see a lot of different faces, a lot of different backgrounds, and you know, those backgrounds reveal a little something about each of the participants. Whereas we would bring folks into a courtroom, a neutral area for hearings prior to the pandemic, here we have people joining from the comfort of their own home. Do you see the picture in the lower right-hand corner? It might be grainy, but there's an individual with some dead animals on his wall. You know, there are backgrounds that involve children and other people in the house. I've heard of stories where Zoom backgrounds include political speech and, you know, flags and items that you know, make a real statement about who the person is, and that might bias you know, the folks who are seeing them. I'm going to check in with the chat here because there's some good things coming through in the chat. Maintaining decorum. Boy, you know, I really hate to bring up the last night's presidential debate, but you know, we saw decorum not maintained there, and it's very much more difficult to maintain decorum when you don't have that neutral location, and where people are more likely to, you know, say things that are out of line, speak over each other when they're on these remote platforms. Let's see, almost instantly a technology and wealth barrier. That's right. You know, if you don't have a webcam, if you don't have an internet connection, again, the libraries and other public access are largely unavailable now. And so it creates this huge access to justice, access to technology gap. An opportunity to provide for a person's day in court. So let's talk about how that feels. The appearance of doing justice, does it feel like your day in court when you just appear on Zoom, maybe from your mobile device for 5 minutes and it's over and the case doesn't go the way that you wanted it to go? Are you going to feel like justice has been served? Where is that procedural justice, and how does that suffer, if at all, through the remote hearings? Let's see, limited access to electronic devices or Wi-Fi. You know, putting those who do not have technological resources at a disadvantage. The right to be heard is literally lost when connectivity is poor. So there have been times, you know, during the pandemic where there have been so many people accessing online resources at the same time that the internet service providers are not able to provide a reliable stream of internet. So if you're in the middle of a court hearing and your internet service provider is maxed out, maybe you're looking, a little bit like if you remember Max Headroom during the 1980s and the Coke commercials, you know, where you're shaking and you can't quite hear what the person's trying to say. That can really inhibit them participating in a hearing and everyone's feeling of the quality of justice. The confidence in witness testimony. You know, this is something we've seen even with in-person proceedings that have taken place where folks who are testifying are masked. Some judges here in Arizona have required alternative ways of protecting against you know, the spread of the pandemic inside of courtrooms, because they want to see the facial expressions, and they want you know, the folks who are testifying, witnesses in particular, to be uninhibited by masks and anything that would affect those expressions. So you know, this is a emerging field, and we could talk all day about Zoom, and in fact there have been quite a few seminars by NACM, by NAPCO, by the National Center, and by other organizations about remote hearings. I just want to point out that the National Center for State Courts has a bench guide, and I'll put links to these in the chat as soon as I'm done with my session here. A bench guide to remote hearings. And also there was an excellent tiny chat series that the National Center has done that in one particular episode covered some of these questions and issues with procedural justice in remote hearings. That was really fascinating, and that I recommend. So let's move on to our workforce. You know, our workforce in the courts is taxed on a regular day. We don't operate the judicial branch with an abundance of resources. And our greatest resource in the judicial branch are our people. As I mentioned, justice is a very human endeavor, and it requires the involvement of court professionals like ourselves in order to administer justice. There are a lot of challenges that the pandemic has raised for our court staff. We talked about some of the practical things of coverage and keeping the court open, but you know, this is a major issue in general wellness and mental health too of the folks who work within our courts. Just kind of going through some of the ways that public trust and confidence can be impacted. You can see this clip here from Slate. This was early in the pandemic. This came out March 16th. American courts' failure to respond to the coronavirus could be catastrophic. You know, so that the eyes of the community and the eyes of our country were kind of on the courts from the beginning and continue to be. And so our entire workforce is operating under very difficult conditions with the eyes of America upon us. Customer service has become difficult. We've had instances of folks coming into the courts and not abiding by, you know, the required public health procedures, whether it's wearing a mask, submitting to their temperature being taken, or, you know, pretty scary, exhibiting signs and symptoms of you know, a respiratory infection. And so those folks who work in court security, who are working at the court counters, are risking their own health and safety in a lot of cases, despite, you know, all that we've done to provide and to minimize those risks. That risk still exists here in the era of the pandemic. Some folks will enter the courthouse with even a more adversarial mindset because of those public health restrictions that they must be under, and maybe that they don't choose to follow, you know, in their daily habits. And so there might be even more of an adversarial mindset as someone comes into the courts. Vicarious trauma, you know, this is secondhand trauma of, you know, hearing cases, let's say, you know, an eviction case that results in someone being homeless during the pandemic. You know, that can cause, you know, the laws followed by the court as it should be, but that can really result in really bad human outcomes that can take its toll on both our judges and our staff. So I just wanted to mention these other challenges that we face as well. And it should be noted that the pandemic is not the only issue that the courts face. Since the inception of courts, we have faced societal challenges. The pandemic is just one of many of these challenges. And it just so happens that we're facing another societal challenge at the same time as the pandemic. You can see in this slide, it says the real virus is racism. We've had, you know, just an explosive social justice movement that has happened at the same time as our pandemic, and that continues to take place. And so this definitely warrants additional discussion outside of the scope of today's program, but it's important to understand too that the pandemic is not the only challenge to the court system, and that we're dealing with multiple simultaneous challenges, and will continue to as history progresses. One of the challenges out on the horizon is the election a lot of election cases are going to be seen in the courts, and so the eyes of the nation will be on the courts again, in addition to the challenges of the pandemic and the challenges of the racism and inequality in our criminal justice system. We might have some issues related to the election on top of all of this. But that brings up why it's just so important for the courts to continue along and continue these purposes and responsibilities. Here's a clip that I took from our own Phoenix, Arizona newspaper. After the death of George Floyd, there was a massive protest. There was also a fatal shooting by the Phoenix police shortly after that as well. And so just massive demonstrations outside in our downtown area. And the Phoenix police responded and I think arrested something like 120 or 130 demonstrators. And they were all brought before the court in their initial arraignments. And I think every one of those arrests, persons who were arrested during the demonstration were released. So this is another example of that check on arbitrary use of government power. Maintaining the rights of individuals, securing the rights and preserving the rights of individuals falls to the court, especially in times of crisis like now, where that action taken by the government is more aggressive. And so I wanted to mention that. And so the eyes of the nation, the eyes of our communities are on the courts now. They've always been on the courts. That public trust and confidence, as we know, creates the reason for being of the courts. The courts just simply can't exist and operate unless there's that public trust and confidence that we're administering justice fairly and that we're holding true to all of those 8 purposes and responsibilities of courts. Our communities rely on the courts as an institution to do that. But at the same time, as you can see by this kind of funny comic strip, they are judging us just as we are judging the litigants in the court system. And so I'm going to turn it over to Todd Brower, who's going to talk a little bit about some strategies that we can use to continue conducting court business and that can preserve the purposes and responsibilities of courts, even in this trying time. Todd?
Thank you, Jeff, and thanks, Gabe, and welcome. So I'm mindful of the time, so if we can advance the slide. So this is my question to you. What's more likely to kill you? A shark attack or in bed? And by in bed, by the way, I don't mean that you have to work while your partner gets to sleep. I mean the bed. So if you can put in the chat, just type shark or bed. And then I'm just sort of curious. So as the answers are coming in, I see a bunch of beds. I see a bunch of sharks. The true answer actually is bed. There are about 5 to 7 shark attacks in the world, shark deaths from attacks in the world, and there are approximately in the United States itself, 450 people die falling out of bed. And like, what's the point of this? And so if we could advance to the next slide. So the point of this really, and the reason that it's important is that social scientists, cognitive psychologists talk about this thing called an availability heuristic, which is that when we make assessments or judgments, we rely on the things which are familiar to us or distinctive to us. Did we just lose my, anyway, I'll just keep talking and we'll go back to it. And that's important, because if we're going to talk about tools and assessments and judgments and how we figure out how to make change in procedural justice and stuff, we need to have a good assessment of what's actually true and what is in our heads as might be the way we think about something. So that these cognitive psychology blocks, if you want to think of it that way, are important to talking about the purposes of courts and leadership in the courts and what you can do as leaders in the courts to ensure procedural justice. So let me go to the next slide. And the next slide is actually a poll. The poll is the question that's on the board. So Jeff, if you can start the poll. What I'd like you to do is ring in true or false. When most court users think about their court experience, approximately 50% of people are unhappy because someone has to win and someone has to lose. So if you can just click true or false on your screen, that will we'll get a poll here. So Jeff, I'll have to rely on you when you can see that there's a significant number of people who have done that, and then you can stop the poll and show us the results.
Excellent. We've got about 71% of participants who have voted, and they're still rolling in.
Good. That's great.
And we're at 78, going once, going twice, going 3 times with 82% of the participants voting. Here's the results, Todd.
Wow, so that's pretty interesting. About half the people say true and half of the people say false. So the real answer is, and Jeff, if we can advance the slide, is that answer is false, because the best predictors of trust and confidence in courts are what we think of as, or what are called procedural equity and procedural efficiency, the procedural justice stuff that we're talking about. And it doesn't actually surprise me. Usually when I do this for judges or for other people, there's a lot more people saying true and very few people saying false. It doesn't surprise me in this group that I get more people saying false, because of course you're court managers. And in fact, this is a public trust and confidence section, and so you're familiar with it. By the way, I should tell you that this slide and other slides that have data and also have sources at the bottom, those are all listed in the email that Jeff sent. I have a document for sources, and then I have the data slides of this is one of them, so that you don't have to spend your time here reading about it. But so this is the basis for procedural equity and efficiency and what it means. And Jeff, if we can go forward. And that the 4 major characteristics are what we call respect, voice, neutrality, and trust. And there are some definitions. And once again, you have this slide to look at your leisure. And it doesn't surprise me that in this group, these are familiar concepts. So the real question then that I have for you, and so Jeff, if we can advance it, is what are the features of your courts that are designed to ensure procedural fairness? And let me give you one of them as sort of start it off, and you can write this in the chat. So one of them that I think about is the whole concept of the adversarial system, where each party is represented either by themselves or by an attorney, and they get their side of the case presented. So if you can just sort of type something briefly in the chat, we can get a sense of what are the things that in your court we're talking about. So a ruling by a neutral observer, a judge, signage, in terms of making things visible and accessible, attention to access to justice. DCM plan, so you'll have to tell me, a DCM plan is a, sorry, this is language access, case management. Absolutely, these are all good things. Written decisions, access in person or electronically to the filing system, absolutely. So, drawing jurors from a cross-section of the population, right to counsel, process transparency, an important one as well. So I wonder if we can advance the slide and you can continue to say this thing. But what I notice, you see, so here's some things that I've thought about, and the truth is they mirror, unsurprisingly, all of the things that you've mentioned: process, judges, neutral observers, case management, accommodations for people with disabilities, or translators, or self-help centers, access to technology. I will mention some other things that I'm sure you've thought about, but maybe doesn't show up in the chat, which is not only judicial ethics, but NACM has a model code of conduct for court professionals, which is designed to ensure these very same kinds of things, as well as leadership and change management processes and procedures. In other words, if you think about efficient uses of courts, leadership and change management stuff is an important part of it. And you'll see two links, which are also in the materials that I've given you, to some National Center resource guides. One's on just that, leadership and change management, and the other on public trust and confidence, right? So that it's really nice that I see this. No, you go to the next slide, it's fine. All right, so the question is, why does it matter? And it matters because all of the data that we know, and you'll see that huge list of sources there, is that when litigants believe the court process is fair, they're more likely to comply with court orders and to follow the law. And if you think about 2020, one of the things that's happened in 2020 is protests against authority, sometimes the police, sometimes in favor of the police, against health authorities in terms of mask compliance, criticism or loss of confidence perhaps in other institutions like the post office or the voting process. And there's a tremendous amount of stress that people are feeling towards institutions in general. And courts, of course, are one of them. And yet the court depends to a large degree on people following court orders and following the law. So that things that lead to a lack of confidence, a lack of procedural justice, are in fact things then that are going to increase the problems and stresses that the institutions are under and that court users are under, and for us as court personnel that we are under. And that if you look at this, it says, when litigants believe the court process was fair, right? So that fairness is one of the key aspects of what we're talking about. And I have, in the next slide, we're going to watch a very short video. The video is about something called the monkey experiment. You may have actually seen this, but each monkey has a task and will receive a reward. And the task is to give a rock to the scientist. So the next slide, please. So you need to know two things. You need to know that monkeys like cucumbers, but you also need to know that they absolutely love grapes. So we'll go to the video, and Jeff, I think you're gonna have to click it to start it.
Getting grape, and you will see what happens. So she gives a rock to us, that's the task, and we give her a piece of cucumber and she eats it. The other one needs to give a rock to us, and that's what she does. And she gets a grape. And she eats it. The other one sees that. She gives a rock to us now, gets again cucumber. She tests the rock now against the wall. She needs to give it to us. And she gets cucumber again.
All right, so we can go back to that before we do this. So as you can see, right, there's a tremendous amount of frustration when in fact you don't believe you're being treated fairly. And that's true for monkeys, capuchin monkeys. It's true for people. You can probably remember back in your childhood when you thought maybe your brother or sister or somebody was getting something that you didn't get. It's deeply ingrained in us, this concept of fairness, and we feel very strongly a sense of unfairness when we feel it's happening to us. And that's important because of what the next slide is actually going to show us. So now, Jeff, we can go to the next slide. Not all court users or the public, all segments of the public feel the same. So that one of the things that we find, so this data happened to be from the National Center between white and African Americans about whether the court system is fair and impartial or provides equal justice. The actual numbers are much less important than the pattern that people who are members of minority groups, be they race or ethnic minority groups, or for that matter, gender minorities, sexual orientation minorities, people with disabilities, people who are in poverty, people who are lower income. There is almost always a gap between people who are members of the majority group on one hand and people who are members of these minorities. And it's true not only from the National Center data, but all the way across the board in a whole host of measurements. And that gap then is important when we think about procedural fairness, because in fact, not all court users are similarly situated with respect to these various dimensions. So if we go to the next slide, here's just another kind of question, and we see a similar kind of pattern, because of course that's true. One of the other things that's true about this pattern is that it's not only members of minority groups who feel this way. In fact, if we ask, so the National Center didn't ask this question, but it's been asked in other ways. If we ask the public at large, do you think the courts are fair, equally fair to whites and blacks, for example, or gender minorities and sexual minorities, or people with disabilities? There is that same gap, right? That the general public perceives this difference. And that's significant when we think about procedural fairness for all of the reasons, right, that you can imagine. Because if the public is perceiving that gap, and if people who are in these groups are perceiving this gap, it means that to them, they have a less positive view of courts and their court experiences. And that's particularly important, I think, in 2020, because we know that COVID and other kinds of things that are going on here are disproportionately affecting members of minority groups, either racial or ethnic minorities, when we're talking about police, for example, but also COVID, as well as people in poverty, people who are homeless, people who have these other challenges in their life. And that is increased in 2020 with everything that's going on. So I wonder if, we can go to the next slide. So here are things that we've already mentioned about remote hearings, impact on people with internet and other kinds of technology deficiencies, court backlogs. At some point, these cases are going to come pouring into the courts, and the courts are going to have to deal with them. And we've talked about the fact that 2020 reveals certain weaknesses or stresses on governmental and other systems, healthcare, social safety net, the economy, and of course, courts, and that institutions, confidence in institutions has been shaken. So I wonder if in the chat then, you can talk about the things that you've noticed in your court system that may not actually appear on this list, because this is the stuff we have talked about, but I'm very interested to know what else you're seeing, since you're on the ground dealing with these things. So if you can do that, that would be really helpful. And if in fact, this captures it. Oh, budget cuts, that's absolutely true. And I have forgotten that, but I shouldn't have, because in fact, the university is also facing those budget cuts. If in fact, there's something I haven't missed, in other words, it's already there, is there a particular way in which you can see this coming out in your courts? A defendant's uncomfortable appearing in person or no remote options beyond plea by mail. Financial issues, making changes to the courthouse safer during COVID. Absolutely, that goes along with budget cuts, but that would be on top of even a full budget, is that it's going to be more costly to do those things. Absolutely, those are challenges. Access to a sufficient number of potential jurors. Right, when I don't know whether jury trials were ever stopped. They were here in California, they're back on, but the jury pool is certainly different, as well as figuring out how to do a jury in this time socially distanced. Emergencies versus what the executive branch can do, the judicial branch versus executive branch in emergencies. Absolutely. So why don't you continue to do that while, if you think of them, while we go to the next slide. So I can't help it. I'm a law professor. I think in terms of homework. The good thing is I'm not going to give you a midterm, and I'm not going to grade you, and I'm not going to obviously collect any of this stuff. But as part of the tools, I want to give you some sort of self-assessment take-home. And once again, this is the material that's in the stuff that's provided by email, right? So I have 4 aspects that I'd like you to think about when you come home and you step away from all of the, both this session and the other things that NACM is providing, about access to courts, about the interaction between court staff and the public, about understanding court proceedings and ensuring individual voice. And then the next slide, please. As well as some particular dimensions that might otherwise get overlooked. And one of them, actually, we mentioned that Jeff had that photo of somebody starting their court experience, which starts in a very different way than it did pre-pandemic, right? But the whole process of someone's entering the court system, the where, there are different kinds of things, jury service and counter and staff services. We know, for example, data-wise, that most court users actually access the court through those aspects of the court, but also traffic and small claims and family and juvenile cases are other areas in which there's a tremendous amount of interaction between court users and the courts themselves. And then who? In addition to self-represented people, limited English, culturally diverse folks, I want to think about staff and court personnel. Because one of the things that we sometimes overlook, although I'm sure you don't, given your roles, is that the courts are not only a mechanism for decision-making and the kinds of things that we think of the role of courts, but they're also places of employment. And personnel and HR and staff and court personnel issues as employees, employer-employee stuff, shapes not only the workplace as a workplace, but it shapes the workplace in terms of people doing their jobs and interfacing with the public. And then lastly, I'll caution you, although I'm sure you know this as well, is that oftentimes when court users think about courts, courts includes the police, law enforcement, and the whole mechanism of stuff afterwards. So in Arizona, Gabe said that probation officers are within the court system. In other places, they're not. But in people's heads, court users' heads, when they think of fairness, when they think of access to courts, when they think of procedural justice, often people come to court believing the whole system, including law enforcement, is part of it. And so when we're thinking about sort of self-assessment, think about the fact that what we think of as courts is not necessarily the way other people do. And so these are the so I have one, no, that's fine. I want to go and finish with something called an awareness test. So thank you, Jeff. And if you can start the video, it's a short video.
This is an awareness test. How many passes does the team in white make?
Go!
The answer is 13. But did you see the moonwalking bear?
And that's the takeaway that I'd like to leave you with. That when we think about procedural justice and the other issues that we've been talking about today, particularly the impact in 2020, it's really easy to miss what we're not looking for. And one of the goals of my self-assessment that I get to at the end is to make you conscious of things that we know about, but are not always at the forefront of our brains. And so hopefully the session gives you some thoughts and tools to move forward. And we have time for some questions. If you have questions, please put them in the chat. I know that I'm happy to do that. We can, if you go to the next slide, our contact information is also on the next slide. I won't speak for my fellow panelists, but I'm always happy to talk to you about these issues. So we'll have some time for questions, and then I know that Kathy wanted to say a few words before we leave. So thank you very much. And if you have questions in the chat, please put them in there.
Yeah, just a reminder too, you can raise your hand and we can open up your mic. I'd love to hear your voice as well. Okay. TJ, your mic is open.
Hey, Jeff. Hey, everybody. Given all the conversation as of late, about access to justice and from a racial justice perspective, through this lens of purposes and responsibilities, how do we suggest, involving our court leaders and our judges in discussion and dialogue around those issues in a way that still preserves our, sort of third branch and independence and, and whatnot?
Do you want me to start this and you guys can jump in? So I think it's a terrific question. And of course, on one level, there can be judicial branch education, right? In other words, you can have judicial branch education on these topics. And I'm sure you do, but I mean, you can ensure that the branch education includes those kinds of issues, not only in like fairness courses, but in other kinds of courses. So I don't know, you're doing something on evidence. You can make sure that racial justice issues are presented as part of that, or for that matter, you can use examples in which race may play a role, either an important role or one in which a judge, for example, or whoever you're presenting the training to, needs to recognize that it doesn't play a role. I see this, for example, in domestic violence and other kinds of trainings. We sometimes ignore that not everybody is similarly situated with respect to their interactions with law enforcement or with the courts themselves. So that is, I think, the most direct way, but I'm sure there are others that my colleagues will talk about.
Yeah, thanks, Todd. I'll just offer a couple of quick thoughts of my own. One, sort of connected to what Todd was saying in terms of education. Bias or the requirement to be unbiased is one of the ethical requirements of judicial officers and court employees. And so I think a way to address issues of racism, systemic racism, society, a lot of these issues that have been brought up, is partially through that. We have an obligation to ensure that we are not behaving in that way. But I think beyond that, overrepresentation, for example, of racial minority groups within the system has been an area that I think the judicial branch has long played a role in, both researching, so providing data, working with academics to research that, but also engaging in the conversations of why that might be happening. Are there systemic things that are occurring within the judicial branch? Obviously, the judicial branch can't fix all of society's ills, but we obviously can play a role in unwittingly supporting those ills. And so I think the judicial branch being at the table at those discussions is critical, and in my opinion appropriate, given other boundaries and caveats. Another kind of final point I'll make is I once heard a speaker at a conference say that with regards to how the law enforcement system or the legal system generally deals with seriously mentally ill, again, it's not the court that plays the sole role, but judges have a unique ability to make phone calls that people will answer. And so being somebody who convenes meetings and discussions, I think, is also a role. The judicial branch still has a lot of prestige in society and with other branches. And I think using that to address issues within society and as an extension within our branch, I think is just something that we can do and should do, in my opinion.
Yeah, there's another interesting question that came in over the chat. What do you think is the best way to eliminate confusion of the police and law enforcement and prosecutors, for that matter, being part of the courts? That is the public perception.
Well, I think that's a hard question, but I think one of the aspects of procedural justice, which you're familiar with, is this idea of education and public education and outreach to the public. So I think in many ways, the most direct way to do that is to do that through that public outreach and to see if it's possible, right, to make those distinctions clearer in people's minds. Now, obviously, something like Law and Order, in which the TV show has both aspects in it, right? I mean, you're fighting against the media and you're fighting against popular perceptions. But to the extent that the court engages in education, public outreach, and things like that, I think that might be a place to start with that.
Yeah, and I think it's real important, separation of powers, that perception, things that are going on, in the courthouse, the connections between court staff and judges and law enforcement and prosecutors, or for that matter, defense. All those issues of perception that are woven throughout, our codes of our judicial codes of conduct as expectations are important for just this reason. But at the same time, too, I think as an acknowledgement that, the justice system as a whole is judged by the public, and I don't think there's a way for us to escape those other aspects of the justice system that feed into the courts. And we are ourselves a government institution. So anti-government feelings or feelings of injustice towards the government are projected on the courts as well. But I think it comes back to just judicial independence and doing things proactively to demonstrate that the court exists to check other government power, and that we exist independently of these other parts of the system, and to not miss any opportunity to get that message across, passively or directly.
And one thing I'll just be really brief about and close, I know we're at our time here, melding what Todd and Jeff both said. I think there's a good deal of internal judicial branch education that can be done along the lines of separation of powers, making sure your staff knows why they should be hesitant, for example, to wear the City of Phoenix shirt that the law enforcement staff might be wearing that day also, or location of offices, or interactions in public. This isn't per se an ethics class, but those are the kinds of things that help reinforce. There are simple messages that are sent to the public that reinforce those things. So I think making sure that the branch staff themselves understand the importance of these concepts and the ways that they can manifest a complicated message through their actions is critical.
Yeah, and we are at time. It's been a great program today. I really have enjoyed working with you, Todd and Gabe, on this program. I wanted to open up the mic of Kathy and TJ. I know that they wanted to say a couple of things in closing as well. So the floor is yours, Kathy.
Thank you, and thanks again for putting this on. I really appreciate the partnership with NASJE on this leadership session. As we know, we could go on with the purpose and responsibilities of the courts for more than an hour and a half, as we just kind of touched on it a little bit here. The core curriculum, I know everyone on the call is familiar with that. You can dive into it even farther with that. But I just think now more than ever, we're entering an age where we're really going to have to show the purpose and responsibilities of the court. And as the court evolves, we still have to show why that is so important. We did think of that with next year's conference themes. For those of you that haven't seen it, the themes for 2021 are Justice for All, Courts at the Crossroads, one, surviving the global pandemic, and achieving racial justice. And I think not just racial justice, but diversity and all. So as we enter this age, those things are going to become very important. So I really appreciate the three of you touching on this, and it was a fantastic presentation.
Excellent. Well, on that note, thank you all for joining, and this concludes today's program.